can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury.
It is not the...
What I can't fathom is the district attorney's intent to put a circus in front of this jury. That's defense attorney Kevin Reddington, and the words didn't just hang in the Plymouth County courtroom air. They landed like a detonation, a flash bang thrown into the well of the court before a single witness has even been sworn. Think of what we witnessed here as a legal phosphorus burn. Once ignited, it cannot be extinguished, and it illuminates everything both sides want hidden in the shadows of this trial. Before we go deeper into what the documents actually show, make sure you're subscribed to Trial Theory Unsealed, because we don't just cover the story, we follow the evidence.
Fireworks in the courtroom and opening statements haven't even been presented yet. That's how tense things are in Plymouth County, Massachusetts, where 35-year-old Lindsay Clancy is accused of murdering her 3 young children, strangling them with exercise bands in her upscale South Shore home. But here's the thing, Lindsay's defense doesn't deny it. In fact, they admit...
The Commonwealth of Massachusetts versus Lindsay Clancy. The surface reading is simple: a mother accused of strangling her 3 children with exercise bands in the basement of an upscale Duxbury home.
Everything. Lindsay Clancy breaking down, tensions running high in the court, and we're going to take a closer look at all of that. But first, let's backtrack just a bit to discuss how we got here. Now, I've been reporting on this case since it broke 3.5 years ago, and since then, a major question has emerged. Did Lindsay Clancy murder her 3 young children in cold blood, or was she suffering from postpartum psychosis and had a true mental break? Now, the Commonwealth alleges the former, that Lindsay Clancy acted knowingly and with premeditation, murdering her 3 young children. That's 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan, strangling them with exercise bands on January 24th, 2023. But since the incident, Lindsay's defense and her former husband, Patrick, have been steadfast that Lindsay was suffering from a mental break at the time. They don't deny that she killed the children, but they do deny that it was murder. Now, at this...
The state calls it premeditated murder. The defense doesn't dispute she killed them. They stipulate to it. That's Exhibit A, a stipulated fact that collapsed the trial into a single question of mental state. But the prosecution is calling 17 first responders, 17 separate narrators of the same horrific aftermath. And that's where the structural irony lies. A legal system ostensibly designed for efficient fact-finding transforms into a theater of cumulative emotional testimony. The official position claims evidentiary necessity. The observable reality suggests something else entirely.
I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
No.
Before asking them to consider a lack of criminal responsibility, it is a procedural argument fought on emotional terrain.
Hold back.
I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just...
And here's the hard evidence coldly separating official language from courtroom reality. The defense has filed a motion to limit these witnesses.
This was the precursor for Reddington's motion, asking the Commonwealth to limit the number of first responder witnesses they plan to call.
This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, you know, let's face it, you know, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual heard screaming in the basement, went in, saw the kids in the basement.
We stopped the soundbite there, but Reddington goes on to list 17 different first responders from various agencies, all on the Commonwealth's witness list.
So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here, and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other,
Arguing cumulative testimony serves no purpose other than to inflame the passions of the jury, one right after the other after the other. The prosecution counters with simple math. 3 child victims, the defendant herself treated at the scene, Patrick Clancy transported to the hospital in shock, multiplied by the chaotic trage of first responders moving from child to child, baby to 5-year-old, the witness list multiplies into a mosaic of mutual trauma.
When it's time for the Commonwealth to respond, things get tense all over again.
Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
The statute at the center of this collision is Massachusetts General Laws Chapter 278, Section 33B, the lack of criminal responsibility defense, colloquially mislabeled as the insanity defense. The burden sits entirely on the Commonwealth.
The Commonwealth has proved the elements of the offense beyond a reasonable doubt. The Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. So that means 0 burden on the defense to prove that Lindsay Clancy had a mental disease or defect. In fact, It's all on the burden of the Commonwealth to prove that despite any sort of diagnosis, that Lindsay Clancy was criminally responsible at the time of the murders. The statute goes on to specify, to establish that the defendant
they must prove beyond a reasonable doubt that any mental disease or defect did not deprive the defendant of the substantial capacity to conform her conduct to the requirements of law. The defense carries zero burden, zero. That's the structural reality underpinning every strategic decision in this courtroom. Which brings us to the unavoidable pressure point in this entire proceeding. When a legal system designed to determine criminal responsibility forms into a parade of suffering where a seated juror, already sworn, stands inches from the defendant and declares publicly.
On day 2 of all of this, there was some additional drama when a previously seated juror came forward in front of both the judge and the Commonwealth and the defense. And let me tell you, he was emotional. He was loud. I even could hear him over the white noise. And this is what he said. It's a direct quote. "I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible. I don't think I can handle it." And mind you, all of this is said just inches from Lindsay Clancy herself.
"I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible. I don't think I can handle." What exactly are we asking this jury to do? Are they weighing the substantial capacity of a woman on 13 psychotropic medications? Or are they being asked to survive an emotional endurance test where the evidence of the crime scene itself becomes the prosecution's closing argument? 3 children, Cora, Dawson, and Callan. Their names are the moral refrain that anchors this trial. Cora, Dawson, and Callan. Not abstractions, not legal constructs. 3 human beings whose deaths are stipulated to, whose manner of death is undisputed, and yet whose memory of an evidentiary battle over which witnesses speak for them, how many times and in what order. Cora, Dawson, and Callan. Every procedural motion, every heated sidebar, every tearful prospective juror dismissed, all of it orbits these 3 names. The judge has taken no action on limiting witnesses, acknowledging this will be raised again.
He began crying. The judge made note of this motion, but ultimately decided it was too early to rule on anything definitively.
I guess probably just so you be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings, or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties raise. This is exactly why we have motions in limine, so I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action on that.
Court is dark on Friday.
Opening statements are expected Monday. Patrick Clancy, the remarried father who filed a separate lawsuit calling his ex-wife's medication meant a cocktail that created the perfect storm of terror, will be the Commonwealth's first witness. The defense will question him under special circumstances beyond standard cross-examination, permitted to introduce their own narrative of postpartum psychosis early. There is a publicly filed motion from July 20th available through the Plymouth County Superior Court docket.
Was regarding a motion that Patrick Clancy himself filed on July 20th. In this motion, Patrick Clancy requests that multiple pieces of evidence be impounded, meaning they could not be released to the media or the public. The motion reads in part, "The potential harmful and everlasting emotional impact to Mr. Clancy and his family of any public dissemination of such graphic and sensational evidence and exhibits related to his 3 children is immeasurable." The items that Patrick is hoping to keep away from the media are the following. The 911 call that Patrick made when he found Lindsay Clancy and the 3 children, photos of the children, including autopsy photos and photos of them before their deaths, the clothing that the children were wearing at the time of their deaths, and, quote, material Patrick gave to both sides. Now, Patrick was not in court yesterday for this.
Where Patrick Clancy himself requests the impoundment of autopsy photos, the 911 call, and the clothing his children died in. Pull that filing, read the language of a father arguing against the permanent emotional impact of public dissemination. Then ask yourself the only question that matters at this stage. Is this courtroom seeking justice, or just witnesses? If you're following this case as closely as we are, like this video, share it, subscribe to Trial Theory Unsealed, and turn on notifications. We're tracking every filing, every motion, and every moment this courtroom tries to contain what cannot be contained.